sense. I see.
So welcome to you all to our last panel, which will focus on current and future global challenges for international commercial courts. And the topics that we will address are the importance of innovation for international commercial courts, the pitfalls of innovation, the role of AI, and also the question how much technology those courts actually need, because the disputes that might be brought before them might not necessarily always be suitable for online dispute resolution anyway. We will also address the impact of COVID-19 on the dispute resolution process and how those newly established courts are dealing with those challenges now and in the future. And allow me to briefly introduce our panel. We have on the panel Professor Anna Nylund. She's professor at the Uptake University of Norway. And her specializations include civil procedure law, in particular the Europeanization of civil procedure law, mediation, alternative dispute resolution, and comparative civil procedure. Then we have Erlis Themeli. Erlis is academic researcher at Erasmus Law School. His PhD focused on the competition of civil justice systems in the European Union. Erlis worked before in the banking and litigation department of one of the largest law firms in Albania, and he was the head of the project sector at the High Council of Justice in Albania. And finally, our third speaker is John Sorabji. John is a barrister at 9 St. John Street and lecturer at UCL. He specializes in data protection law, but also constitutional law and procedural law. And his recent research focused on the legal challenges of COVID-19. Prior to joining his chambers, John was a senior lawyer advising the Lord Chief Justice, Master of the Rolls, and other members of the senior judiciary on various legal issues, from data protection to freedom of information. And John teaches at UCL various courses in civil justice and alternative dispute resolution, and is also a visiting professor at the University Paris 2. I also would like to mention that he's the general editor of the White Book, which has been mentioned this morning by Sir Geoffrey Foss, and he co-edited also with Xandra the book on international business courts, a European and global perspective. So thank you very much to our panelists, and I give the floor to Anna.
Thank you very much. It's really an honor to be here today with you. And I'm going to share some ideas and some experiences that I have from research on rightly national courts coping with COVID. But I think these are very much transferable to international commercial courts. So I think it goes without saying that the COVID pandemic has entailed a giant leap in digitization that has removed some of the obstacles that have deterred people from turning to ICCs. But I would also say that the very same innovations and developments have rendered most cross-border proceedings and litigation less cumbersome. And there is reason to believe that digitization is likely to sharpen competition among courts precisely because some of the obstacles and hindrances have been removed. And thus, in my view, to become highly attractive alternatives to national courts, ICCs must be in the forefront of digitization and also put AI into use and understand what AI is about. And my perspective is uniquely Scandinavian in the way that I represent a country and legal culture where we are highly digitized societies. We're open to digitization, and also we have quite efficient courts, and therefore we have been hesitant to actually, our lawyers are hesitant to actually litigate in international commercial courts. I should add that part of this has also to do with the Hague conventions that the Nordic countries have generally been quite reluctant to recognize and enforce foreign court rulings. And I wish to, I feel like the topics that I wish to address today is very much going to be reiterating what Sir Geoffrey was said this morning. And one point is an issue is the uptake of technological innovations and the pitfalls of technology. And the other main issue is AI, artificial intelligence literacy, and transparency regarding the use of AI in courts. So the first topic, the uptake and pitfalls of technological innovations. And I think in this regard, it's really important that ICCs can outperform national courts, or at least be on par with most of them regarding the use of technology, both communication technology and artificial intelligence, to be attractive to litigants. And it's important to keep in mind that technology must not just be there, it must also be used and also function well. The research that I've done with my colleague, Professor Bart Krans from the University of Leiden, demonstrated that there are many courts that have access to digital platforms, etc. But the problem is, for instance, that you can file a case, but you cannot pay the court fees online, or you cannot pay them from abroad. And that means that actually you don't have a very attractive filing system, or that foreign lawyers cannot use that system. And the other problem is if you don't want to use remote hearings where appropriate, or try to revert back to old habits as soon as possible, because, for instance, you have bad internet connections, or because you feel uncomfortable and you don't take the time to become comfortable with the technology, or, for instance, that you don't think about such more practical things like, where is the camera, what about lighting, and can the parties see you, do they feel heard? And even with professional commercial parties, I think we should not underestimate psychological factors. And then just making use of technology isn't enough, sort of going from paper to digital, but still doing the very same things and structuring proceedings in the old manner. So a court should really try to be as innovative as possible and tap into the potential that technology affords us. And in that regard, I think Sir Geoffrey was said this, that they should reimagine the structure and content of proceedings. For instance, communication. We used to think that if it's written communication, it's asynchronous and formal. And today, of course, we know that this is not the case. And then oral communication might be asynchronous and very informal, and does not have to happen with everybody in the same room. But I think that new technology also affords us new opportunities to present both evidence, but also legal arguments. We have software that helps the parties assess risks, facilitate settlement, the negotiations, and so forth. And to be attractive, you could also have in place this more multi-door courthouse and integrate these tools into both litigation and sort of pre-litigation and during litigation mediation proceedings, because the window for mediation might open at any stage of the proceedings, as we've also heard being said earlier today. And then going on to AI literacy and transparency regarding the use of AI, I think one issue is what kind of AI do courts actually use? And I think we should be particularly mindful of technologies that are already applied and that we don't necessarily regard as AI and take them for granted. And for instance, databases where judges seek and obtain information regarding legal rules and case law. It's one example, because of course we know that depending on what database we use, we will, and what word searches we do there, we will find very different results. And thus the law might be different depending on which tools you use. And then, of course, since much evidence is digitized and we have a huge growth, annual growth in the number of documents and megabytes and gigabytes and so forth that are produced, we should also question what kind of technologies are using to obtain and to analyze and to present evidence, and how do these technologies work? So what's the algorithm like, and how are they employed, and how they're regulated, and how do they interact with other types of regulations? And are there any caveats? And if so, what are those caveats? And in my mind, of course, courts should put these tools into use, and I think that could particularly render ICCs attractive to commercial litigants. But then we also need transparency regarding what tools are put in place and how these work, as I've said. And I can understand that there is a challenge, because it's not easy to frame the logic of AI in terms, in language and logic that's really understandable to humans, but at least it's important to understand that that must to some degree be done, and that those who are both transparent and innovative are probably going to stand out as the winners of this competition, or at least as the trailblazers and those others look up to. And then the final issue that I would like to address is the AI literacy of judges, and AI is everywhere. Of course, we know we can today manipulate films. You see, for instance, there's this film of Obama, President Obama of the US, and he says things that if you know him, you know that this is fake, that he cannot have said this. But do judges know how that's done and how manipulation is so easy? New cars today in Europe, they will suddenly stop without the driver having done anything, because they detected something that the car thought was an obstacle. It could be, for instance, a cyclist where there was plenty of room, but the artificial intelligence in the car tells the car to make a almost full halt immediately, and then stops and creates a dangerous situation, and so forth. There are many of these examples, and of course the technology used to draft commercial contracts and other contracts. And do judges, are they familiar with these technologies, how they use? Do they understand how machine learning occurs and how algorithms function? And I think to potential litigants at ICCs, it's important to be able to estimate the level of AI literacy of the judges at that court, to know whether to educate them, and also in some cases where AI is very important, to understand the implications of that for the outcome in the case. So to conclude, I think that ICCs should really seek to be the innovators, the ones who are trailblazing in this regard, in both developing digital and AI tools, and actually seeking to tap the potential of technology, but also to implement these tools and in a way that renders proceedings more efficient, and also yields, if one could say, correct, just practicable outcomes. And I think that many ICCs are in a unique position to actually do this and to embrace AI and technology. And some of these courts, I think, also actively aim to be the leaders in the field. However, as a European, I'm a little bit concerned regarding the European courts, because this morning we heard about some of the difficulties they have faced due to regulation and local rules that are in place and practices. And I think that we in Europe should be critical because and support our courts as much as possible so that we can keep pace with what is happening in Asia. So thank you.
Thank you very much. We hand over now to Erlis, please.
Hi, I hope you can hear me.
Yes.
Okay, yeah. So thank you, Eva. Thank you, Xandra, for having me. It's a pleasure to be here and to hear all these knowledgeable people talk about the topic that I like a lot, because it's the topic that I studied during my PhD. And when I started my PhD, a big watershed of the time was the 2008 financial crisis. For us today, then this watershed is actually COVID-19. And I have some slides to share. And I think I'm the only one because I guess John will not have. I hope you can see all my slides. Yes. So then at this point, we kind of measure or tell about things before and things after COVID. And things after COVID turned out like this. There are judges and there are human lawyers, but there are also cat lawyers. And well, while this is funny, the story is that at some point when the COVID-19 pandemic started, this happened. So courtrooms were emptied. Lawyers and all the other litigants were obliged to stay home and to contact the court via their computers or through electronic systems that some courts put up in a haste. But what exactly happened actually in the Netherlands? Well, when infection started to be problematic, the Dutch government, as probably you know, in all other countries, decided to lock down the entire country. This included courts, which remained empty for almost 2 months. Then gradually they started to accept a small number of parties and then also public. Courts moved everything online and parties were obliged to communicate with the court digitally. Now, this was the case also for the NCC. And the NCC actually was kind of better prepared than most other courts because it had already set up a system called the ENCC, which was a system where parties were able to submit documents, to check the schedule of the court, to see the documents that the other parties have submitted, and then in the end also were able to litigate and to have hearings. But the number of cases that were dealt by the NCC during this time were minimal. If I'm correct, actually, there were 2-3 cases that they handled during that time, and I'm speaking about the first half of last year. So the number of cases that the NCC dealt was not enough actually to draw some conclusions. But then we can see what happens with the courts in the other, let's call the normal courts in the Netherlands. Field studies have shown actually that there were some problems with people in these courts. Many felt a general online fatigue while litigating in these conditions. So being far, being away from their lawyers, being away from the judge, not having good connections, and many other problems that Anna mentioned. This increased attention disorders. So for many people, it was difficult to keep attention alive, even for lawyers that were supposed to be the professional party in this proceedings, but also for judges, it was difficult. This situation made it even more difficult also for people that were digitally illiterate or people that were challenged with technology. And online hearing in general was considered to be more burdensome by both lawyers and judges. However, if we compare the NCC with normal courts, of course, the NCC is different. The number of cases is small, the parties mostly exchange document, and most importantly, lawyers and their teams are tech savvy. So we may assume that they are somehow immune from this system. So technology can be a good thing for the NCC. And now comes the crucial point. What type of technology do NCC and courts like this deserve or need? Well, we may try to divide technology in two types. We may think of technology that helps judges and court administration, and technology that can replace judges or court administration. Now, support technologies or helping technology are good because they can reduce costs, can help judges to decide faster. However, there should be also a balance here. So as I mentioned, while the NCC can be immune to the problems that litigants faced in normal courts during the emergency days, but something that can be the new normal now. This can happen also with while litigating before the NCC. So somehow technology should not be the goal at this point, or at this point. Technology in general should not be the goal, but technology actually should be a mean to help parties, and that comes also from the name, helping technology. So and in addition to this, it's also something that Sir Jeffrey mentioned in the morning. Technologies and digital technologies may pose also risks for a fair trial. It may reduce also the publicity, or paradoxically, can remove anonymity in cases that are needed. And on top of this, again, digital or digitization fatigue may emerge. So when it comes to technologies that actually can replace either judges or court administration, like artificial intelligence or systems that rely on artificial intelligence, I think that no matter how advanced, they will not be accepted very easily by court users, especially in this type of courts, so international commercial courts. One reason for this is that court users pay a premium price for this in these courts, and they expect a premium service, something where humans are still relevant. Meeting in a courtroom is not only about justice, but often in this type of cases, it's also a kind of show for many lawyers. This is a big part of the litigation experience that lawyers, but also their clients are trying to get and have been paying for, and removing it, it can be counterproductive for many of these courts. Moreover, if advanced systems that can replace judges exist or can be deployed in courts, governments would be under pressure to use them in other courts. So in courts, what I called before normal courts. And now if these systems are everywhere, so both in ICC courts, or let's say if they are at the NCC, but they are also at other courts in the Netherlands, I struggle to imagine what is the added advantage of the NCC, apart from using the English and some special procedures. But then if the one that is replacing the court is just a system, then again, the advantage of the NCC compared to the other courts would disappear. But then again, considering the global or regional competition between international commercial courts, digitization in one country does not, digitization does not depend only on what is happening in one country. It also depends on what is happening in other countries. Because if we see a competitive pressure from, let's say, courts in Asia, but also other courts in Europe to use certain type of digital systems, the NCC, but also, well, any other court for that reason, would be compelled to use these digital systems. And as Sir Jeffrey said this morning, technology should reflect actually the needs of court users and should not be an obsession. For that reason, again, for me, the biggest question, and that is also my point in this presentation, is to understand what is the need that court users have, how they perceive technology, and whether or not this technology or what kind of technology do they ask from court administration, for the court administration and from the government that is sponsoring these courts. Well, I try to be brief, but this is my presentation. And well, I'll be happy to take part in the discussion. Thank you.
Thank you very much. And I give the floor straight to John.
Thank you very much. And thank you for inviting me. I've focused, or I've been asked to focus perhaps on the future in my short presentation. And whenever I'm asked to think about the future, for some reason, I'm always reminded of Jim Morrison, because in one of the Doors songs, he sings the line that the future's uncertain and the end is unclear. And I always think that that's probably the best response when anybody asks you to talk about the future. But given that the best response has already been taken by somebody else, I'm going to just talk about, I think, 4 short points about what we may see for the future in terms of ICCs and digitization. Now, obviously this morning, the conference started with a keynote address, if we can call it that, by Sir Geoffrey Voss, the Master of the Rolls here in England and Wales. Now, 11 years ago, so the past, not the future, his predecessor as Master of the Rolls, Lord Neuberger, expressed his own view on what the future may hold for international disputes. And particularly his focus then was international disputes concerning cross-jurisdictional insolvency matters. International commercial courts, ICCs, weren't on his radar at that time. And he focused on how different courts in different jurisdictions could in the future work together. And he particularly alighted on the idea that for cross-border matters, where proceedings go forward in multiple jurisdictions, that in the future may result in, as he put it, simultaneous hearings with satellite communication. Of course, that was novel, innovative 11 years ago. And he also suggested that we may see a division of labor between those different jurisdictions and their courts. As he put it, I suspect that we are moving inexorably towards the development of intercourt, cross-jurisdictional framework agreements, of joint and simultaneous hearings via video link, and so on. Talk of satellite communications and video links today is in some ways a little bit like talking about telegrams in the age of the telephone. The painful ubiquity, we could put it, of Zoom, Teams, WebEx and the like, which we've all adapted to, I won't say adopted, but adapted to over the last 18 months, has perhaps moved us a little bit closer to Lord Neuberger's vision, and perhaps faster than he would have imagined if we'd been holding perhaps this conference in February 2020 BC, before COVID, that is. Now, of course, the COVID pandemic and its promotion of remote hearings and its turbocharging, we could say, of the use and development of digitization may lead to the realization of simultaneous cross-jurisdictional hearings particularly between the growing members of ICCs, quicker and faster than we might have imagined. And it may ultimately lead further than that. And I'm going to just leave that hanging in the air for the moment where it may ultimately lead. But how might we get there if we're going to try to realise Lord Neuberger's vision quicker and faster, particularly using COVID-related inspired technology? So I want to focus in that respect on 4 brief points. So the first, our starting point, is that if we're going to develop Lord Neuberger's vision further and have greater cooperation perhaps between ICCs in the future, we need to review the significant steps forward that we've taken with our use of digital technology over the last 18 months. Now, its rapid expansion into all areas of court proceedings has, of course, been unprecedented, and we know it's generally worked well, notwithstanding the critical points that Erlis made about Zoom fatigue, which we're all now familiar with. It's, as I said, generally worked well, but it's worked well and enabled courts to continue their work in an emergency situation. And there are things that we will accept in emergency situations that are perhaps not optimum in normal times. And I don't think that anybody should simply be thinking that we should adopt what was the new normal for an emergency into an ongoing normal unreflectively. And we're already starting to see some reflection. For instance, to give an example from London's commercial court here, we're already seeing a rowing back from the use of remote hearings. Now, we see here an instance of the legal profession urging a step back to more physical hearings, more real hearings, as we might say. And why? Why might we want to do that? Well, the answer is simply that the effect of remote hearings has harmed the subtle dance of litigation and negotiation. It has removed the prospect that you can cross a floor, cross a waiting room, and talk to your opponent before you go into the court, and maybe settle, maybe reach an accommodation. That we are seeing, or at least it's been reported, we are seeing is starting to be lost by digitization. So we may all in the future be able to move around a version of Abu Dhabi, the Abu Dhabi Global Market Court's fully digital courtroom, but a common digital courtroom, perhaps with simultaneous hearings in multiple jurisdictions, is likely to lose the ability to have informal talks, informal discussions, to observe your opponent in the way that we would do in a physical hearing at the moment. So one of the things that we may want to review in the future, as we learn the lessons from the pandemic, is, well, if we're going to create or adopt more digital courtrooms, design more effective digital courtrooms, are we going to have to also develop a fully digital courthouse, door to the court, waiting room, ways to replicate, if that's possible to some extent, what happens in real physical court spaces? And we may need, of course, to do that in order to ensure that effective commercial negotiation and settlement can continue just as much as commercial litigation and adjudication. So if we're going to get to a commercial jurisdiction without borders, operating through remote technology, we need to get a better idea of what works and what doesn't. Now, digitization could provide a firm foundation for such a growing commercial jurisdiction, but we need to understand the wider and unintended consequences of its use if we're going to provide a firm foundation for ICCs to cooperate with each other further. So my first point, the future needs reflection. The second point we need to consider focuses on data security, particularly where ICC hearings involve commercially sensitive material, either individually or through hearings being held simultaneously across borders. Now, it's going to be necessary, I think, to give proper consideration to where hearing data is stored, for instance. Now, one point that the Standing Forum of International Commercial Courts made earlier this year in a report that they issued on how commercial courts, international commercial courts, had dealt with the pandemic was what to do with hearing data in terms of deciding which jurisdiction is going to store it when an ICC is using it digitally. Are you going to store it in a jurisdiction that has a good record of data security? If different ICCs are to work cooperatively in the future, there's going to be a need for a common set of data security standards, or at least for agreement on a common cloud service provider in a reputable jurisdiction for all ICCs to engage in, particularly if they're engaging in Lord Neuberger's jurisdiction across borders approach. Data security is one of those areas that I think I can cautiously say, was not always given as much emphasis as it ought to have been during the pandemic. The focus during the pandemic, of course, was let's keep things running with less real emphasis on ensuring, as you might have expected, that data security standards were always properly at least taken account of. I assume that they were always adhered to, but it's not clear, at least from the information in the public domain, that it was necessarily the case that data security was paramount in people's minds. So, second point, data security. The third point, and Anna got there first on this one, we need to consider innovation. But let me see if I can give a different perspective on innovation. One of the consequences of the recent growth of ICCs is that there has been, and there inevitably will be, an increase in procedural innovation. Competition, again, Erlis's point, for work between these courts is undoubtedly going to spur the ICCs to experiment, to look for further ways to innovate procedurally. We saw this before the pandemic with the financial markets test case procedure as an innovation here in England and Wales. And no doubt, ICCs are going to use the pandemic and the turbocharging of digitization as a means to look at new and more innovative ways to use digital technology, and to do so faster than they would have done in the past. So, as Anna mentioned, evidence is going to be an area where we're going to see particular innovation. AI perhaps is going to be used to assess the merits of commercial disputes. It's something which is already being promoted in international arbitration to a degree. At least that's what certain service providers on the internet suggest. So are we going to see different ICCs adopt different digital processes to the use of AI? Are we going to see AI-assisted early neutral evaluation in some jurisdictions, perhaps? So one thing that we might say, particularly given in some jurisdictions where ICCs are particularly well funded, is the ability for those jurisdictions to innovate more adroitly than might be the case in others. So we're going to see a marketplace of innovation, I think. Now, where ICCs operate under the Neuberger model, simultaneous hearings, and what we may well see is that the use and familiarity of innovative approaches are going to be more readily understood and appreciated, both in terms of how they work and their pitfalls, more broadly across ICCs than perhaps would have been the case in the past. So we might see broader and quicker adoption of approaches that work. We may see the rejection of other approaches more quickly. But what we are likely to see is competition spurring digital innovation, which in turn spurs more innovation and more competition and more adoption of what succeeds. Because what succeeds is going in a competitive marketplace for courts, which was the starting focus for this conference, the competition across international commercial courts. We're going to see more of that competition. But in doing so, more of that competition may ultimately lead to greater familiarity, greater commonality, as what succeeds is adopted more broadly. My final point then, where is this going to take us perhaps? Well, Maya Steinitz recently considered the case of a single international commercial court. The giant leap in digitization that we've seen over the last 18 months, and as Anna described, caused by the COVID-19 pandemic, may provide the basis on which one such single international commercial court could evolve over time. Simultaneous hearings, innovation leading to common standards, competition leading to more innovation, leading to greater adoption of those common standards, may ultimately provide a framework, not just for increased cooperation between ICCs, but that cooperation may ultimately lead over time, and no doubt cautiously through evolution, the establishment of a shared vision of a single international ICC with an overarching jurisdiction. I leave that perhaps terrifying thought as one hanging for the future. But as they say somewhere else, from the many, and there are many ICCs at the moment, we may ultimately end up with one. Thank you very much.
Thank you very much, John. This opens a whole box of questions, I would say. Let us start though with those that have been asked in the Q&A. I can see two questions here. So the first one comes from Maria Carlotta Uchin. The question goes to Erlis. She says, if I understood correctly, you pose that users of commercial courts may not want AI, preferring human judgment, but this assumes these users are all far away from the benefits of AI. But as we argued earlier, new cases may be brought to these courts, like conflicts related to blockchain and smart contracts. Don't you think that in these cases, the users would be willing to have AI applied?
Well, thank you for the question, Carlota. I think I divided technology into two big chunks. One is technology that helps the court, and the other is technology that can replace the court. And by the court, I mean, of course, the judge. Now, if a case is about smart contracts or blockchains, that is extremely difficult to untangle. Well, of course, it depends by the type of the case. But then if you are going to talk about the details of the blockchain or the smart contract, it might be a bit difficult to discuss about the technology that is behind that, because once these systems are in place, then yeah, they kind of develop on their own. Anyway, I think that for this type of cases, or cases that involve artificial intelligence, of course, courts can and should use artificial intelligence to assess this case, to assess the facts, to assess the process and whatever is related to them. However, my argument and my point was that in international commercial courts, parties would be a bit shy to use a technology that replaces judges, because they, in my opinion, and from what I understand, many lawyers would prefer and would like to be in front of the judge, but also what John described, to be in a waiting room and meet the parties and discuss, because that is probably the only chance that they have, or they really had, to talk in a quiet place with the other parties. So the answer to your question would be yes, they would be willing to use artificial intelligence to help the court, but they might not be very willing to use artificial intelligence to replace the court.
Thank you. There is a question from Georgia, which is slightly related to the earlier question. Could the use of remote hearings or AI in international commercial arbitration offer some insights with regard to the question whether parties before ICCs prefer the digitization of proceedings or not?
Is it again for me, or?
I think it is for you, but probably for everybody. But
well, my short answer would be, well, the ICC kind of copy arbitration as well as arbitration copies ICC, so they would look at each other, and that was also one of my, well, I mentioned it in my presentation, that it doesn't depend only what happens in one jurisdiction. Everyone copies each other. John mentioned it as well, and
Can I just jump in there as
yes.
well? I think absolutely that what goes on in international commercial arbitration, and particularly the use of remote hearings or the development of the use of AI, is going to be influential in the development of procedures in ICCs. And I think that's not least because of the fact that in some jurisdictions, I'm thinking perhaps Singapore being the key one here, because of the link which they have established between their international commercial court and their arbitral offering, it will inevitably result in cross-fertilization because they intend to develop them together harmoniously to support each other. And I think in other jurisdictions where that model is going to be adopted, and undoubtedly it will be in many jurisdictions, as soon as it's shown to be successful, as I also think it will be, then inevitably you're going to get that cross-fertilization. I think in some senses we need to stop thinking about necessarily ICCs and international commercial arbitral centres as being separate from each other. I think the future, particularly in some countries, is going to be that they're two halves of a complementary dispute resolution offering from that jurisdiction.
And if I may say something, I definitely agree that there is every reason to look at what's happening in the field of arbitration, and also that the most innovative sort of national courts who are not formally international commercial courts, but who in practice, as we've heard today, function as such, could also be very innovative, and then they also participate in this market for cross-border dispute resolution services. And I think also that these specialized proceedings for different particular kind of cases there can also be innovations that then spread into other kind of proceedings, although not originally designed to be used on a general basis.
Thank you. We have another question for John from Luana Picot. She says, could you please develop your thoughts on using AI for assessing the merits of a judgment?
Sure. I'm not sure that I may have put it perhaps the wrong way. I wasn't talking about assessing the merits of a judgment, so using the AI to test what the judge has decided or intends to decide. I was more focusing on the idea that AI could be used to set out what, to predict what a judgment may be. And in that sense, I think we need to just think about two things. First of all, if we can develop AI to effectively do this, and there are skeptics about that, Nicholas Vermeij in Canada has particularly, and I think quite forcibly, made the point that it may well actually be impossible to effectively use AI to predict court judgments or set out what a judgment ought to be, due to the amount of data that an AI program would require, and the fact that we don't have enough judges and judgments to be able to feed the beast, as we could put it that way, that AI may be. However, let's assume that you can get a degree of accuracy or predictability, as has been shown by some studies, in terms of decisions or judgments. In that type of situation, I think that we ought to be considering using any prediction in terms of the outcome of a hearing as a guide for judges rather than as the decision itself. As a sense check, we could put it that way for judges, just to help them reach their decision, to check that they're not reaching a decision which is so markedly off the wall that no reasonable judge could reach it. So use it perhaps as a tool to improve judicial decision making rather than as a replacement for judicial decision making. And some jurisdictions may use this more than others. Law firms are already developing their own programs. I know that Berryman's, not plugging them at all, have marketed themselves as using predictive technology to help advise their clients on the merits of their cases. So if we're using that type of technology already to a degree for law firms, then I don't see why we can't use the same type of technology for judges to help them as an aid to the decision-making process. But of course, given the needs for transparency, Anna's point, any such prediction or material that the AI provided to a judge to help them with their decision making ought, of course, to be provided to the parties. And they ought also, of course, to be provided with an opportunity to respond to it, if, of course, it's going to help in any way, shape or form. It can't be something done in secret under the table that only the judge knows about. This type of material ought to be made available.
Thank you.
May I say something about this? So this is an interesting topic because, again, it comes back to what I'm saying. At what point do we need to stop to implement this type of technologies? As far as I know, the technology right now is up to the point where AI systems are able to identify arguments in texts. So these systems actually have a big library. They can run through the library and identify arguments and paragraphs, sentences that can be used to justify a certain type of decision. However, they are not able to write a full decision, or they are not able to come up with new arguments in order to justify a certain type of decision. Now, the difficult part of using artificial intelligence will come when these systems will be able to draft a decision. Because at this point, judges may be pressured to accept the decision or the draft of the AI without changing it. And then at that point, you might say, okay, the judge is kind of signing the decision, but is the judge taking the decision? Is the judge thinking about that? So then, okay, again, when developing and implementing this system, at which point should we stop implementing them, and which stop should we stop using them? Yeah, well, then I don't know. I suspect at the point where they will be able to replace judges, but we don't know the future, as Jim Morrison said.
Anna, would you also like to comment on this point?
I could actually comment. I saw there was a new question, sort of what if the judge is not bound by what the AI says, and because I thought I could return a little bit to what John was talking about, these discussions and negotiations between lawyers, and then if we think of a more integrated dispute resolution system with this multi-door courthouse, then you could actually think that maybe AI could be used and these decision systems to sort of make these early evaluations of the case, and to maybe identify a settlement range that would make it easier for the parties to then negotiate the final settlement within that range, or to give them an indication of arguments that might not prevail at all, and in doing so actually simplifying the case, because some parts of it would be settled early, or the parties would simply drop those claims or presenting those arguments. So I think at the previous stages, the use of AI could be even much more fertile than trying to replace the judge or guide the judge towards a certain decision.
Thank you. I have a question relating to this. We had some discussions during another event on which types of proceedings would lend themselves for a fully online setup in the future. And I was wondering, and that means including automated decision making. Do you think this is something that we can expect in the foreseeable future, maybe for cases that do not require any discretionary decision by a judge, because either it's a very low value case with simple legal questions or very simple factual backgrounds, or could you see a future where this really goes to a fully online setup with decision making beyond what we know maybe from platforms like eBay, etc. So for commercial cases as well, with a simple factual and legal setup. This also came up in the context of corruption in justice systems, and some parties arguing that they might actually prefer such a decision over the decision from a judge in a country where the justice system is maybe less reliable. So I wondered what your thoughts were on this point.
If I start, I think for simple cases, we already see that to some extent. So that's not in the distant future. It is happening right now. And I think one problem is also when these cases are then appealed, and many of them, these kind of decisions are of course made outside courts, and do judges really know and that it was AI who made this decision and it was completely generated automatically. But I think when we're talking about international commercial litigation, we're talking about such complexity that it's down the line somewhere, but predicting whether that's 5 years away from now or 10 or 20 or perhaps never really going to happen, that I won't do today. But I definitely think that we will see much more of it and sooner rather than later.
Who wants to go next? Erlis, do you want to go?
Yeah, but to answer the question of Eva, I think that conflicts can be also we can use kind of a chart. So conflicts can be either low in conflict or high in conflict. It depends how much conflict parties have between each other, but also how the conflict resonates with the general society. Conflicts that are low, so where the conflict is low, are suitable for artificial intelligence. Then the other thing that we could see is also the complexity of the case. So if the case is too complex, cannot be judged by artificial intelligence. So therefore, we should take these two ingredients and see which conflict has a low, which case has a low conflict, but also a low value. And those cases are also easier to automatize, to be resolved by AI systems. And actually, these are also the cases that eBay resolves. They don't have difficult legal questions. The conflict is not that big. It's, yeah.
Finally, from me on this one, then, I think 2 points. I think we may well see fully online, I'm not suggesting AI, but fully online for shorter hearings, interim hearings, case management hearings in international commercial courts. That certainly would appear to be the evidence that we have from the experience of the pandemic here in England and Wales. So I can see that being a general point of development, never mind in ICCs. The second point, might we prefer to use AI in justice systems where the judge is perhaps not viewed to be as reliable as they could be? Well, that I think just raises another question in my mind. If you don't trust the judge, why are you going to trust the person who devises the AI system? Because it's the same. Because if you don't have faith or in the probity of the state, in one sense, why are you going to trust it in the other? And I think Carlos Espluges has written about this, about putting faith in AI systems and how if we use them for procedure in future, where we're simply creating the tyrant's charter, as he puts it, because you can fix the AI any which way you want.
Thank you. I have another quick question on the topic of online hearings. I know that it has been very straightforward in England following the pandemic. Online hearings have not been as straightforward in other countries. For instance, in Switzerland, there has been a huge discussion because the Swiss federal court wasn't actually happy to allow those hearings if there's not an agreement between the parties on that matter. I was just wondering what will the future be? I mean, we had a bit of a discussion about it already. Will we see proceedings where online hearings are optional if the parties decide to have them? Or do you think this will become a sort of default setup potentially for court proceedings? Where do you see the future basically on this matter?
Shall I go first then? I think we will see a huge variety because the study that I did with my colleague Bart Grans, that we really saw the variety. Some courts in some countries, courts in many countries, they just started doing online hearings, and then there was no way going back. And of course, when things become more normal, there are more in-person hearings, but those the remote aspect of it, or the hybrid aspect of it, they will definitely remain as a part of the everyday functioning of the court system. And in those countries, then there's those halfway, and then those that completely reject and even reverted back to almost written proceedings. And I think it depends very much on what kind of case you have and what the parties wish. But I think there will be a preference for courts that are more flexible, that have good facilities for hybrid hearings, that are flexible in sort of developing hearings that fit the remote and or hybrid format much better than regular conduct of hearings. Actually, it doesn't fit very well, or some aspects of it doesn't very well fit into a remote context. So I think there we will see that those who are willing to take the technology into use will be winners. And I think Denmark is an example where courts were reluctant for some reason to use remote hearings, and the result was cases going to arbitration, because arbitration tribunals were willing, and they were willing to hear these cases in simplified proceedings. So it was sort of a win-win, and that sort of illustrates how quickly the tide turns, and those who are good at implementing new technology are the winners.
I agree with Anna. I think we're going to see a broad range of hearing types being offered. For some hearings, types of hearing, it will be the default. I mean, we can see that as the future for small claims hearings. We know that is on the cards. For as I said earlier, shorter interim hearings, I think the default is going to be in some cases that they are online. But for the rest, it's going to be, I think, it will depend on the circumstances of the case. I don't think we're going to see necessarily uniform patterns. We're going to see a variety, and courts and parties picking and choosing what suits them the best in the particular circumstances of the case and the hearing. So a smorgasbord, perhaps.
Erlis, would you also like to comment on this point?
Well, my colleagues told everything that was to say about this, and I agree. But again, for me, we have to be careful about this, because, well, we may offer all these systems, but then making them obligatory, it might be also counterproductive. As I said, there are all these situations where people are not able to communicate with the court because of, I don't know, digital illiteracy, because of other problems. And most probably these are also the cases that can be more easily digitized and digitalized. But then again, these are also the cases where people have the most problems. And then, yeah, what do you do? Well, you can leave it as it is, and then they go to arbitration or to some form of mediation. But then you can also use more technology in court and make sure that they don't get lost in the arbitration and private settings of dispute resolution.
Thank you. I have one last question that goes to John. So you mentioned the view that in the future there could be a single international commercial court. And I found that an interesting remark, but I also wonder why.
Why? Well, I suppose the thought that I had was that as there's greater cooperation and greater commonality of procedures as a result of competition and the adoption of the most successful, the most attractive procedure, that necessarily perhaps we might see ourselves walking along the pathway of consolidation. Why have 15, 16 different ICCs across the world based on individual states' jurisdictions? Why not pool that jurisdiction to create a single court to enable cross-border, particularly international commercial disputes, to be to be resolved more in a more streamlined fashion? And that really came from thinking about what Lord Neuberger was talking about 10 years ago, when he was talking about a single dispute having to giving rise to proceedings in multiple jurisdictions. Why replicate? Why not adopt the principle of concentration of proceedings on an international level and just resolve the dispute all in one proceeding? And rather than give that proceeding to one jurisdiction, why not have an international one? So that was really the thinking behind it, that we may end up heading in that direction through a process of evolution and development.
I think that's a very interesting thought. I know that Cassandra is very keen to comment on that question as well. It's interesting in many ways, but also I think you might get some problems, because actually dispute resolution is a huge market for the different jurisdictions, and I'm sure they would easily give that away. But I hand the floor over to Cassandra now. Thank you very much.
I had a couple of smaller questions, but I will leave them aside because we're running towards the end. Also, to follow up indeed on that was one of the questions I had as well, on the single international commercial court. Of course, we have an ICC already in Paris, but that's a different one. Then how would you see it then? Because I don't see this as a realistic future, in the sense that, I mean, even in the EU, they have already said, well, this is probably not where we should head. And then if this is within the EU, not really seen as something that can be done in a short-term future, then to have it at an even broader European or worldwide level, I think that is very complicated. Maybe The Hague would want to volunteer as being the location, also hosting other international courts and criminal courts and whatever. But I think that is it's an interesting thought. Maybe it was just like, okay, you know, I let this idea up, but I wouldn't know how, even, of course, also being a private international law lawyer, like, oh, what about international jurisdiction? And who I will see more litigation about, or a negotiation maybe about where the court should come and who and what and why and who should be on the court, then that, yeah, this court can ever resolve a dispute.
No, I'm sure it was an idea that I was throwing out there in an uncertain future. Yeah, I'm sure it has many things going against it, but you know, it's nice to think about the possibilities. And given that Maya Steinitz had developed the idea, I thought, well, perhaps we might be able to give it some give it legs, as we could say, based on what's been happening. But you never know. Never say never.
Yes, I think if there are no further questions, I thank our panelists